All right, well, let's continue the conversation because joining us now is Stanford law professor Doug Melamed. Doug also oversaw the Justice Department's antitrust division as acting assistant attorney general, served as Intel's general counsel. It's great to have you here, Doug. And before we get into the DOJ case against Apple, on Europe, I mean, it's kind of a pile-on, and they're going about it in very different ways. They have this tech legislation. Should the U.S. and Europe be more coordinated here?
Well, it is a pile-on, and it would be nice if they were more coordinated. But they have very different philosophies, increasingly so. Europe is much more inclined to regulation. The U.S. proceeds in a case-by-case basis. I think it's really important to understand that the DMA is a kind of regulation. In the U.S., if there's a dispute about conduct, the plaintiff has to show that the particular conduct was actually bad, actually injured competition. Under the DMA, there's a regulatory scheme that prohibits or has certain requirements for categories of conduct. And the question is whether the companies have complied with the regulations, not whether the particular conduct they're engaging in is actually anti-competitive. And I think that difference in approach makes it very hard for both Europe and U.S. to be fully aligned in these matters.
So you sound. I sense some criticism. A hint of criticism there in the regard for how Europe is going about antitrust regulation.
Well, my personal bias is to be skeptical about broad regulatory prohibitions like those in the DMA. But there's just a difference in philosophy. There are pros and cons. Do you want to have to go detail by detail, or is it more efficient to have broad categorical rules? That's a big subject of a lot of debate. I come out on maybe the U.S. side of that, but it's not an easy argument.
Well, what do you think the U.S. is trying to accomplish, which raises that question at the DOJ when it comes to Apple? Because interestingly, if you compare the two approaches, the U.S. had a much broader complaint suit against Apple, everything from the hardware to the software to the apps, and it's not clear what the end result is going to be. We just know it's going to take a really long time to litigate.
Well, it is not clear what the end result is going to be, and the U.S. is clearly, under the current leadership, Assistant Attorney General McCanter, who's heading this case, is very aggressive. They want to push. They want to not only deal with problems that they perceive with the networks and the platforms like Apple, but they want to push the law in some important respects. The complaint is a very sophisticated complaint. It's a serious case. It's largely based on existing law. It draws heavily on the Microsoft case, which was finally decided in 2001, but it pushes the boundaries in a couple of important ways regarding a firm's ability to control its network and to choose the partners with whom it's going to deal on the network. The courts generally in the U.S. have been very conservative about those kinds of issues, but the government is hoping that it has put together a set of facts that will motivate the courts to maybe push the envelope a little bit on what the legal rules are with respect to those networks.